This lecture is titled Forest Rights Act, Conceptualizing Indigeneity in Rights. Now, Forest Rights Act was enacted in 2006 in India, and it seeks to assign a jurisdiction to indigenous peoples' claims over land, forest, and resources. It can be seen as a model for conceptualizing and legalizing indigeneity within the rights framework. One of the biggest challenges for legal regimes has been to level the gap between the rhetoric of legal pluralism and the practice of it. Indigenous peoples' rights to collectives. Who is to be the bearer of these rights? What ought to be the degree of enablement of these rights? One of the problems with writings or entitling collectives is that social groups, together with cultural aspects of community identity, have a notoriously indeterminate core to which rights can be pegged. Besides, once assigned and enabled, they also develop capacities to confront civil and political rights like right to property. Hence, as a concept, social, economic, and cultural rights are often trimmed and honed and shorn of their deontological excesses such that they can cohabit easily within the same framework as individuated entitlements of civil and political rights. In the plethora of entitlements that have found their way in international covenants and treaties, cultural and group claims have often been disingenuously formulated and articulated. This disingenuity stems from a tension between the discourse of collective, group, and cultural rights and their legal conceptualization. What is this tension? On the one hand, liberal discourse seeks to increasingly adopt and articulate the language of rights in order to mitigate the suffering and poverty that afflict a large part of the global population. It holds out the grant of rights as modes of inclusion, while on the other hand, it is in a quandary over a proper response to groups identified by culture or ethnicity that want a differentiated treatment in order to preserve characteristics they cherish. Now, rights ambition is a difficult stance to adopt, and even minimalist ambitions can be misplaced. But this is why the Forest Rights Act of India is very important and in some senses a forerunner in assigning indigeneity a jurisdiction. In what can be termed as an Occupy law instance, the Forest Rights Act stands out as an exception. I say occupied because the Forest Rights Act law can be seen as subverting the original meaning and practice of property. This occupation can be understood as a form of subversion that spatializes property in order to shift focus away from the propertied subject on to broader networks of relations that interact to form property. It asserts a jurisdiction for different practices of belonging, where belonging between a subject and an object and between a part and a whole become indistinguishable. They negotiate the uneasy correlation between rights, collectives, cultures, and reconfigure law in terms of an alternative geopolitical space that seeks to occupy law and disturb its bias against collective form of ownership. Let me briefly outline the provision of Forest Rights Act and the moves it makes. Forest Rights Act was enacted, as I said, in 2006. It expanded the constitutional provisions that protected loose territorial claims of tribal communities over tracts of land or forests they inhabited. While the Forest Rights Act is located in a maze of dense, imbricated, and conflicting jurisdictions, it is also true that the FRA importantly have devolved power to village-level Gram Sabhas or village councils, paving way for participatory democracy. I'm calling the Forest Rights Act FRA from here on. The final text of the FRA was an outcome of a compromise between two competing narratives. At one end of the spectrum was the campaign for survival and dignity, that campaign for the removal of the oppressive control of the forest bureaucracy on forested tribal homelands and its replacement by restoring democratic control over forest governance to statutorily empowered village assemblies. At the other end of the spectrum was a forest bureaucracy supported by highly vocal, hardline, urban wildlife neo-conservationists, popularly dubbed as the Tiger Walas or the Tiger Guys. They were distrustful of local communities and found them vulnerable to incitements of short-term gains that would put forest and wildlife at risk. They continued to press for a statist model of conservation, a centralized bureaucratic forest management that would prevent a substantial devolution of power to communities. So the FRA was an outcome that was a kind of a middle ground, but because of the conflicting background, there were multiple opacities in the final text. But there are different ways to see. One way, of course, is to see it as something that has imbricated jurisdictions, at conflicting jurisdictions, multiple opacities, which typically emerge when competing interests and narratives are sought to be reconciled. Another way would be to see the FRA as a space where constitutive relations between forest dwellers and forest is altered and instrumentalized through a language of rights and conservation, as opposed to what Sabyasachi calls a teleology-free sense of belonging. A third way would be to see it as an interruption of the colonial discourse of governance. Now, C.R. Bijoy is an expert and a leading campaigner of the FRA, and he says that if you look at the legal history of India, essentially what we had was a colonial administration where a subjugated land and people had to be governed. In the revenue, forest and other departments, this whole attitude culture sort of continues. It is in this enduring context of law's continued allegiance to coloniality, law in governance of subjects rather than citizens, law creating subjecthoods rather than citizenship, that FRA occupies a distinct, albeit a peculiar position in the Indian framework of law. Bijoy calls them the first governance laws based on participatory democracy, not just through representatives, but by the people themselves. Now, there are two very distinct features of the FRA, or the Forest Rights Act. First, it seeks to restore the rights of forest dwellers over land for cultivation and habitation, over community forest resources and habitats, and it seeks to restore the governance and management of forests to communities. Second, it devolves power to village-level councils or Gram Sabhas who have a legal capacity to contest and exclude alienation of land in scheduled areas. Let me outline some of the key provisions of the Forest Rights Act that have enabled jurisdiction for indigeneity and a capacity to the village and tribal communities to contest alienation of land that they inhabit. The most relevant part of the FRA legislation is Section 3, Subclause 1 of the Act, which can be summarized as a bundle of following rights. The first, title rights. So there are ownership claims and rights that are being farmed by tribals or forest dwellers as on 13 December 2005, subject to a maximum of 4 hectares. Ownership is only for land that is actually being cultivated by the concerned family as on that date, meaning to say that no new lands are granted. The second set of rights are use rights to minor forest produce, also including ownership to grazing areas, to a pastoralist routes, etc. The third would be relief and developmental rights to rehabilitation in case of illegal eviction or forced displacement to basic amenities subject to restrictions for forest protection. And the fourth, forest management rights to protect forests and wildlife. From 2015 onwards, recourse to forest rights law has enabled, firstly, village and tribal communities in various states of Orissa, Chhattisgarh, Maharashtra, Arunachal Pradesh to veto land acquisition claims of corporations and state governments by simply refusing consent. It has bolstered legal claims of tribal and village communities by devolving a capacity to village councils to contest alienation of land and resources in scheduled areas. And most importantly, borrowing from Sarah Keenan's formulation of subversive property, it subverts property by spatializing it. So rather than a focus on the propertied subject, it shifts focus to the space that surrounds the subject. Put differently, it gives a jurisdiction to a different practice of belonging, where belonging between the subject and an object and between the part and the whole become indistinguishable. In subverting the property frame, the Forest Rights Act makes two major moves. First, it moves away from the absolute idea of property that combines the Blackstonian triad of rights, that is, of possession, use, and disposition, or in modern parlance, the right to exclude, to use or enjoy, and to transfer. What the FRA does is to sever the contingent link between formal ownership and the right to use, or between ownership and possession. For instance, the Indian state has eminent domain powers. Let me explain this. The Indian state has eminent domain powers over land that is outside of private ownership titles, which means that all forest land, natural resources, water are formally owned by the state. But the state is not always in possession of these lands. The Niyamgiri Hills in an eastern state of Orissa, for example, are occupied and used by a tribal community known as the Dongaria Konds. But the state retains the ownership of the Niyamgiri Hills. In fact, in a Supreme Court case between petitioners, which is the state-owned Orissa Mining Corporation, and the Ministry of Environment and Forests, the Orissa Mining Corporation alleged that the bauxite reserves that were beneath the Niyamgiri forest soil were the property of the state. However, both eminent domain claims over forests or over subsoil bauxite reserves by the Orissa government did not alter the fact that the Dongaria Konds were in possession of the Niyamgiri forests and were claiming usufruct rights over it. Having ownership of something or being in possession of something is not always equivalent to having the right to use it. It is in this interstitial space that a subversive form of property can be located. It is doubly subversive because it inverts the libertarian premise of just initial acquisition, drawn from classic works of John Locke and Robert Nozick, and the labor theory of property to make a claim not for individuated property but for collective communal property. The Forest Rights Act acknowledges the initial acquisition of tribal and farming communities as just and then assigns it a juridical weight, making the legal content of this property right both interesting and jurisdictionally instructive. The second move that the FRA makes is to juridify consent. The forest rights law stipulates that before forest land can be acquired for any project, the village councils in the area, the Gram Sabhas, are required to certify that the process of recognition of rights is complete and give their informed consent to diversion of forest land. Forest Rights Act conceptualizes rights of traditional forest dwellers in terms of use, occupation, and exclusion. The latter is a very important stick in the bundle of rights. Understanding the role of consent has assumed significance given the recent histories of eminent domain claims that seek to dispossess traditional forest dwellers of their lands. The standard bundle of rights for landed property include right to own property, represented by a formal title. Second, right to enjoy it to the exclusion of everyone else. And third, right to alienate or transfer it. But the FRA does not employ this standard rights bundle to delineate property claims of forest communities. It does not explicitly spell out the feasibility or terms of transfer. Instead, much of the ownership claims of forest dwellers rests on the right to exclude, implied in the provision of consent. Right to exclude thus becomes one of the most essential sticks in the bundle of rights that are commonly characterized as property. Property as a purely conventional concept has no fixed meaning. It is a fluid category whose meaning can be assigned by each legal system in accordance with its own peculiar values and beliefs. However, there is a broad consensus that the right to exclude others is one of the most essential sticks in the bundle of rights that are commonly characterized as property. In some senses, the right to exclude actually becomes a sine qua non of property rights. Thomas Merrill, talking about the exclusion stick, says, give someone the right to exclude others from a valued resource, and you give them property. Deny someone the exclusion rights, and they do not have property. According to Merrill, the right to exclude is a necessary and sufficient condition for identifying property. It is by embedding this right to exclude in the provision of consent that the FRA makes its second and boldest move by creating possibilities of a subversive form of property. To illustrate, let me briefly tell you how the principle has worked in two case studies that I have selected. One is, as I mentioned earlier, in the Niyamgiri case in an eastern Indian state called Orissa, now called Odisha, and in Raigad, which is a district in a central Indian state, heavily forested, called Chhattisgarh. In both these instances, law's bias against collective forms of ownership is reconfigured both in terms of an alternative geopolitical space and an alternative jurisdictional space. From 2015 onwards, recourse to FRA has enabled village and tribal communities in states of Orissa, Himachal Pradesh, Chhattisgarh, Maharashtra, Arunachal Pradesh, various states of India to trump claims of corporations and state governments simply by refusing consent for alienation of land from their customary possession. Let me take two case studies to illustrate how the Forest Rights Act induces a different practice of belonging. The first is in the state of Orissa, and this relates to a Supreme Court judgment broadly called the Niyamgiri judgment. Now, Niyamgiri is a forested hill considered to be the abode of Niyam Raja, the deity of the Dongaria Konds. A decade-long struggle of 8,000 plus Dongaria Konds to save the Niyamgiri hills from the bauxite mining project of Vedanta Incorporated culminated in a Supreme Court judgment that invoked the consent provision of the FRA and granted 12 Gram Sabhas, village councils, the power to veto the bauxite mining project that was to destroy 660 hectares of rich forest land as also the habitat of the Dongaria Konds and their deity. Provisions of the FRA were specifically referred to by the Supreme Court. The court said that the FRA mandates that concerned forest dwellers be treated as rights holders, as statutory entities empowered with the authority to protect Niyamgiri Hills, and be granted the right to community tenures of habitat and habitation and the customary right to worship the mountain in exercise of their traditional rights, which would be robbed of if the mining is permitted in the Niyamgiri Hills. This is quoting from the Supreme Court judgment. In April 2013, the Supreme Court of India passed a decision that could be seen as inaugurating new forums of judicial action and address of law, one that admitted the articulation of collective cultural claims which had thus far lacked determinant content and legal articulation in India. In endowing the Gram Sabhas with the power to exclude, the Supreme Court made forest community rights defining of the outcome of the encounter between the Dongaria Konds, the Orissa government, and the Vedanta Corporation. My second case study is from the Raigad district in a central Indian state of Chhattisgarh. Now, Raigad is extremely rich in coal reserves and in sponge iron reserves. In the late 90s, Raigad emerged as a hub for power and coal mining. Raigad is occupied mostly by Adivasis and lower caste groups. Agriculture and forestry are the main occupations. A study conducted by a 2-member fact-finding team reported that most of these coal mines came up either on their agricultural or forest and pasture lands. Each and every aspect of the natural resource-based community has been adversely affected by the spread of industrial and mining activity in the district. From 2016 onwards, there has been a growing mobilization in various villages of Raigad against any further land acquisition and forest diversion for mining in the area. There is in general a growing awareness, especially in the post-Niyamgiri period, that communities have a right to be consulted, fully rehabilitated and compensated before mining projects ensue. There is also a growing awareness that provision of consent in the FRA is not merely a duty of the government to consult, but a power of the community to exclude. In March 2016, 5 Adivasi villages, Jaridi, Urba, Madhuamar, Pelma and Sakta, unanimously vetoed the project of the state-owned Southeastern Coalfield Limited to acquire their lands and mine their forests. At stake is over 2,000 hectares of land, including 280 hectares of forests, and lives of 1,250 Adivasis, Dalits, other lower caste families who stand to be displaced. Field notes from these villages reveal that subversion of property happens at 2 levels. First, when a spatialized conception of belonging becomes the marker of both what is property and whose is property. And second, when the contingent link between formal legal property and the right to exclude is detached. These 2 subversions together make it possible to stake possession and use claims even in cases where they do not have individual property titles. It has also made it possible for these 5 villages to exclude state claims over coal reserves and forests. In March 2016, Village Council at Pelma, the Southeastern Coalfield Limited functionaries were greeted with slogans of Bhu Arjan Rad Karo or cancel land acquisition. We want grain, not mines. These were the slogans that were being raised. In December 2016, when we visited Pelma, narratives of belonging and attachment to land were articulated. A farmer said, "We do not want to leave our village. The only conclusion we come to is that if mines are opened, it will benefit none. Our entire existence will be wiped out. Our village comes under the FRA and therefore we vehemently protest against SECL in the Gram Sabha." Dubli Singh Patel, another farmer from Pelma, said, "For whatever reason, we will not give up our forest. Since the times of our fathers and grandfathers, we have managed the forest. There are several animals in the forest. Our gods reside in the forest and protect us. In turn, we have to protect the forest." In areas where there are coal mines, people's complexion has also turned black. These company people sitting in Delhi and Bhopal eat sweets, and all we get to eat is coal dust. We will not give our land. Bhanu Pratap of Urba village had an interesting understanding of his ownership claim. Why should we give up our land to the company? It is our land, our coal. We will dig it ourselves and sell it. We are aware that they are giving us very low rates for our land. Our demand is that we will dig the coal ourselves and send it off in the trucks. We will do according to our will. We are opposing SECL because this is our ancestral land and it belongs to us. The story of these 5 villages is unique, for there's a new solidarity among the landed and the landless. Those who do not own land will neither get a job in the company nor any wealth if land was to be acquired by SECL. But interestingly, it is the better off farmers who are leading the crusade against SECL. The headman of Pelma comes from one of the richest families in the village, with the family owning nearly 200 acres of land and having strong political connections with the state's ruling party. But he is also one of the strongest opponent of selling off their land for coal mines. In both my case studies, Niyamgiri and Raigarh, a relationship of belonging held up by the surrounding space is being articulated. Land and forests are seen as caregivers, a source of livelihood, of heritage, as having meaning beyond that is encompassed when we categorize land as a resource or as a commodity. The tribal communities in every village council strongly articulated the unreliability of what has come to be the routine statist bribe of development. They do not want to trade the relationship with the land and forest for either monetary or material benefits. To convert this rather esoteric, abstract, notoriously indeterminate set of claims into jurisdictional entities is the chief achievement of the Forest Rights Act. The FRA interrupts the legal system that is the root of settler land title law that tends overwhelmingly to protect non-indigenous property. It is important to underscore that property here is defined not just by law, but by a range of social norms, rules, and regulations. The FRA here is not the only network that is producing property. Property here is being produced through a network of social rules, norms, relations, including but not limited to law. A host of scholars, Madhvi Sundar, Anupam Chandra, Kristen Carpenter, Sonia Katyal, Angela Riley, argue in defense of property, albeit a property that protects and is in fact critical for the protection of peoplehood interests, propositions of peoplehood, human flourishing, distinctions between fungible and market inalienable goods are propositions that create a space for alternative conception of culturalized, subversive property rights. The key assertion here is that collective claims of stewardship or custodianship by communities of certain lands and resources ought to be protected through culturally varied, non-proprietary ownership regimes that contribute to the flourishing and protection of community interests. Lack of formal ownership should not preclude claims of land or cultural property rights. As Carpenter, Riley, and Katyal persuasively argue, in many such cases, the custody of such items may be in fact situated in the fiduciary obligations of a collective people rather than rooted in claims of individual ownership. In other words, historical fiduciary obligations of a community towards certain lands, waters, sacred sites entitled them to a culturalized idea of property rights. Granting community rights of use and possession over land is a jurisdictionally more solid proposition than granting them indeterminate cultural rights over knowledge, religious practices, and so on. Territory rights have a determinacy on which can be predicated the more indeterminate and fluid categories of traditional resource, culture, and knowledge rights. It would grant communities an agency that could produce a productive political confrontation with the state. In the absence of right to territory, claims for rights to forests, rivers, biotic commons are always manifest with possibilities of unstable contractual valuations. Robert Sack quite brilliantly sums up when he says that territoriality provides a means for reifying power. Land, forests, mountains are more tangible than culture, power, influence. It is a more effective means of establishing agency and control if distribution in space and time of resources or things to be controlled fall somewhere in between ubiquity and unpredictability. To conclude, let me propose, and I echo Robert Unger here, that there is an indeterminacy of legal doctrine in general and property law in particular. There is an idea that basic notions such as property, contract rights, freedom, democracy, and so on can have alternative institutional embodiments. Such a reading opens up the possibility of a theory for subversive property that can locate itself among alternative social or institutional ideas beyond the internal necessity of rules underwritten by prevalent jurisprudence or dominant discourses. In most jurisdictional encounter between community claims and individualized, corporatized claims over land or valuable natural resources, communities find it difficult to fulfill the conditions of a propertied subject. Rights language, even in its collective avatar, embodies the intuition that every individual has an equal moral worth and remains the primary locus of property rights, even in cases when they accrue to her as a member of a group. Rights usually accrue only to individuals or to collective entities that behave like individuals. Assumptions of authorial identity, representation, divisibility, and market alienability are prerequisites of property right constructions. So it is mostly through a maneuver of framing a collective in the terms and image of an individual that collective rights find their juridical articulation. The forest rights, the Supreme Court judgment, and the tribal voices can be seen as a genre of legal innovation or as a sui generis conceptualization that seeks to expand the practice of law to become more cognizant of community claims and conceptions of belonging. The FRA draws from a perspective that views property as a relationship of belonging to a geocultural space, and that views property law as having the potential to be anti-essentialist and admit claims that are not defined by their possessive character. The meaning of property is therefore not fixed or essential but spatially contingent. This spatialized understanding of property opens up an alternative political agenda for property, one that is not reproductive of status quo, but has a potential to be subversive and unsettle spaces. And when subversive property falls within the parameters of law, law comes to be occupied by alternative, non-essentialist agendas. Thank you very much. Would have been happy to take questions, but since I'm not there, you could email me and I'd be happy to get back to you.